Here's 3 easy things that should be in your will. First, you should identify your heirs at law. An heir at law is someone who would inherit from you if you were to pass away without a will. This is determined by your family and the laws of the state in which you reside at the time you pass away. An estate planning attorney can help you determine who is and is not an heir at law. It might include your spouse, your parents, children, grandchildren, or even siblings. Second, you should handle beneficiaries who may inherit from you who might be a minor. A 7-year-old cannot cash a check given to them from your estate. And even if they could, you probably wouldn't want them to. We can handle that usually through some kind of testamentary or standby trust. Third, you should pick who you want to manage your estate, to follow the directions in the will, often with the help of an attorney under the purview of the probate court or something similar in your state. This is known as the personal representative, sometimes called the executor or administrator, depending on when they're serving and what jurisdiction they're serving in. You can identify a list of people. You can say, first, I'd like my spouse to do it. And if he or she can't do it, I'd like my dad to do it, or my brother to do it, or something like that. I always like to name successive lists just because we never know what's going to happen. So there's 3 easy things that should be in your last will and testament.